Good evening, welcome. I'm Ed Martin. I'm the president of the Phyllis Schlafly Eagles, also known as Eagle Forum Educational Legal Defense Fund. Thank you for being here. It's such a thrill to be back together face to face. I think it was, Brad was saying it's been, what, a year and a half or 2 years. It feels like 20. Time telescoped or went in and out or something. And so it's just so much fun to see people and to visit so in person. So great to be here. Thank you for coming. This afternoon we had a great panel program. I know I saw many of you there. If you weren't there, we did record it. It was fascinating. Every panelist I mentioned could have probably had a couple hours to talk about what they were talking about in just 23 minutes. So thank you for that. You know, what is patent eligible is really the basic and important question. And patent eligibility, it's just shifted so much, and it's fallen from Congress's clear patent law, the rewrite in 1952, and the reference that we heard so often in the afternoon session, the 1980 reference to, quote, anything under the sun that is made by man as patent eligible. And as we had the discussion today with our panelists about what other parts of the world, Europe, China, are doing, and what we're doing to ourselves in our patent system, there's a lot to be worried about. The Supreme Court, of course, has led the way in the degradation of patent eligibility, of the patent eligibility doctrine over the past 12 or so years. You look at Alice Mayo. You've seen how, and we heard the quotes earlier about how the judicial decisions have been so incoherent or back and forth, and they've muddied up the waters so much that Circuit Judge Kimberly Moore, who now has a distinction, I don't know if she knows this, it's probably in her Wikipedia page pretty quick, but she's now Jim Edwards' favorite judge. I think that happened this afternoon. So Circuit Judge Kimberly Moore called the mess, quote, validity goulash, in her dissent in American Axle. And it was very interesting to hear, despite Brian's glass half empty, hear about how some paths forward and what we can expect to happen in the future. In a few moments, we'll hear from John Schlafly. John Schlafly plays a senior role at our Eagle Forum Education and Legal Defense Fund. He is an attorney himself and serves as treasurer of the organization, but also is our institutional memory. And we also tonight have a very great privilege and honor of having our friend Andrei Yonko come back to us and to address us, the former director of the U.S. Patent and Trademark Office, who did such important work in such a thoughtful and, dare I say, kind way in a time when people were rough and tumble. He just was a great leader and someone that we're so pleased is with us, and we'll hear from him in a few minutes. At this time, let me invite Jim Edwards, who has had enough accolades this afternoon, so we'll stop that. Jim Edwards, come forward, and David Lackman of Bio, we're going to do the pledge and have an invocation. So Jim and David, please. Go ahead, Jim.
I'll wait till David meanders up.
That's what I do.
And we actually have a flag.
We have a flag. Well, shall we?
May we pray? Our Heavenly Father, we thank you for the opportunity to gather together and examine serious matters facing our patent system. We're grateful that we may honor several who've stepped up to address challenges like those in patent eligibility doctrine. We acknowledge that invention and secure ownership are important to you. You're the maker of the universe, the creator of the ends of the earth. Scripture tells us the earth is the Lord's and the fullness thereof. Lord, you created human beings in your own image. You endowed in finite humans some of your own attributes: intellectual capacity, creativity, inherent rights to own what we make, that is, to enjoy the fruits of one's labor. We're amazed at how the human application of these gifts unlock the remarkable discoveries in biology, physics, chemistry, nanotechnology, and other useful arts. We get to glimpse the tiny complexities of molecules and the breadth of the universe. Lord, we're humbled like the psalmist who wrote, "When I look at your heavens, the work of your fingers, the moon and the stars which you have set in place. What is man that you are mindful of him, and the Son of Man that you care for him? With patents to secure private ownership, human discoveries have advanced the human condition, saved human life and improved human health, created vast new industries, created wealth of astounding measure, and enabled unimaginable human flourishing. We acknowledge these truths, and so we thank you for this occasion and for all those who have made this event possible and productive. In the name of the builder of all things we pray. Amen.
If I could ask you all to join me in the pledge, please. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Let me recognize again our sponsors. I want to say thank you to our sponsors in a particular way. They have stepped forward to make this possible. Acacia Research Group, the Biotechnology Innovation Organization, Dinsmore and Shohl, the Innovation Alliance, and InterDigital. Please stand if you're here from one of those organizations right now so we can thank you. Stand up. There you go. Thanks very much. We have a number of special guests. I think a couple of folks that came in and left. I saw Congressman Davidson. He was here and left. We also had an RSVP. I think we expected Congresswoman Virginia Fox to stop by. She sent her regrets. Congressman Glenn Thompson. I mentioned Andrei Yonko, our former Patent and Trademark Office Director. Also, David Kapos, who served in that role, also is here. David, thank you for being here and for being a participant earlier. And of course, the man who holds the most patents of any member of Congress, Thomas Massie. Congressman Massie is up here, and he is taking orders for the Klux capacitor so that you too can have chickens in your yard that can be left. And my wife is deeply concerned that my kids heard about this and want one for our yard, Thomas, so you have a lot to answer for. Let me invite John Schlafly to come forward now to speak about Phyllis Schlafly and her legacy in terms of this commitment, why we keep going with our organization, and also this important issue. John worked for decades with his mother, Phyllis, as her right hand. It was an extraordinary 1-2 punch, Phyllis Schlafly and John. He continues to head up our organizations, also continues to write like Phyllis did. Phyllis wrote a weekly column for somewhere around 40 years. John's on his 5th year writing a weekly column, so he's got some work to do to get up to 40 years, but he seems to be going strong, although he writes it with his brother, so he only half writes it, so it's not quite like Phyllis, but it's a good start, John. We really appreciate that. He's an attorney, and he's got an LLM in accounting, and he's one of the greatest people for understanding what the IRS is trying to do to nonprofits and 501c3, C4, and everything else. So anybody who has an organization that needs help, John is your man. But John Schlafly. John, please.
Well, thank you, Ed. I just want to take a minute to say why we are here, and it's because Phyllis Schlafly cared about this issue. She cared about inventions and patents throughout her life. She grew up at a time when I would say that inventors were folk heroes in America. Edison was still alive, and in her home, inventors were respected. Her father had had a career with Westinghouse. Westinghouse was one of the greatest American inventors, and he formed a company which created a culture that supported invention. So that's how she got her start in this. And, I should mention, though, that there wasn't any one-on-one problem in those days, because the inventions that we all know, that we still know, that came to market in the late 19th and early 20th century, which which the ordinary person could understand their originality and their value. And but time went on, and of course, Phyllis did a lot in her life, and there was a mini-series about her that came out last year and went for 9 episodes, but not a word was in it about patents, so they missed that altogether. She had a number of dimensions to her life, and after she participated in the great American baby boom by having 6 boomers, President Reagan, and while she was doing that, she had a career as a pamphleteer and an organizer, and she was involved in many organizations. President Reagan put her on the commission to mark the bicentennial of the Constitution. And she's one of 18 commissioners, and I don't know if the 18 commissioners were meant to track the 18 clauses in Article 1, Section 8, but in any case, she took for herself the 8th clause of that section, which, as you all know, is what supports this industry, which secures to authors and inventors the exclusive right for limited times to their respective writings and inventions. And then she became aware of threats to the rights of inventors, which began in the 90s. And some of her writings at that point are in the book that was put out on the tables, where then, if you can imagine, the great threat that Americans thought came from Japan. I don't know what happened to Japan. Japan seems to have disappeared from the world scene now, but at that point, the Japanese threat to American innovation was considered significant, and when there was a movement in Congress to diminish the rights of American inventors by changing the system to call for a publication of applications before the patents were issued, she fought against that. And then she fought again a decade later for the threats to the security of patents through post-grant review. And because the security and the reliability and of the invention is what makes it possible to have economic value. So that's a long history of Phyllis's interest in the rights of inventors and the patent system, and we have carried that on in this organization, and we're so glad that Jim Edwards has been willing to lend his talents to pursue this to the new challenges we face with 101, which really just emerged in the last decade, and is the subject matter of this particular meeting, which is our 5th annual of these events to promote the patent system. And it's gotten a lot more difficult, I must say, in terms of the concept of what's involved with patents, because when Phyllis wrote about this subject, she wrote, I would say, for a popular audience, and she wrote in a kind of a romantic way about the romance of the inventor tinkering in his garage and coming up with an idea that was so immediate to the general public. And Phyllis was able to tell how in her own life, how what used to be called labor-saving inventions improved the life of all Americans. And the patent system, she believed, under our Constitution, is what made all that possible. And to just give one example of that is, we'll say, the sewing machine. Now, that's recognized in the history of the patent system as one of the landmarks in the history of patents and inventions. It was about 1850, I think. But Phyllis, when Phyllis was growing up in her own home was basically the same machine that had been invented a century earlier by Elias Howe. And it was still not even electrified. It was powered by foot power. But what that made possible was that Phyllis's grandmother made all of the clothes for a growing family and made sheets and towels and napkins and tablecloths and diapers. There wasn't any paper then. And one elderly woman with a machine was able to make all that for a family. And that's what invention made possible, what the patent system had made possible. And that Phyllis understood that even as a child, and that stayed with her throughout her life, and that's why she was adamant about talking, with enthusiasm about the importance of patents and inventions to our entire American way of life. So that's why we're here, and I thank you all for coming and for participating in this great event. And I applaud each of you for what you're doing to preserve the American system of patents. Thank you.
Thank you, John. And now for some dinner, and then we'll have our after-dinner speaker in a few moments. So enjoy, please. Introduce our main speaker. I'd like to invite Brian O'Shaughnessy forward, please. He's a partner at Dinsmore and Shohl law firm and heads up their IP transactions and licensing group. Also has been a great supporter of our efforts these 5 years for these events and a great sponsor. So Brian, thank you for everything you do, and please come up and introduce our next speaker. Thank you, Brian.
Thank you, Ed. Well, I have the profound honor and distinctly humbling privilege of introducing our next speaker, Andrei Iancu, who, good for me, deserves or needs no introduction to this crowd, but nonetheless, I'll indulge in a few things. Andrei left his role as the managing partner of Irell in Manila. So like Cincinnatus, he left his plow in the field and went off to Washington to fight the good fight and do the service of his fellow members of the Republic and did great work. So we thank him for that. So in his government service, I don't know what you left behind, Andrei. Was it a plow or was it a briefcase or what? But at any rate, it was a noble calling, and he surrendered a very lucrative career, no doubt, at his firm of Irell in Manila and came to Washington to serve his fellow citizens. And of course, he did an admirable and remarkable job in doing that. And if you'll indulge me for a moment, I'll relay a brief anecdote about my first experience with Andrei. So early on in his tenure, the Licensing Executive Society leadership came to meet with the new director, and I believe Kim was there with me, and Brendan was there on the other side of the table with Andrei, and we sat down to talk about the importance of IP and how we had to do something about this model of efficient infringement. And, you know, he was still very much an unknown commodity at that time. Andrei, I think to his credit, did a very good job of a listening tour for a while before he actually spoke publicly about his positions and his policy objectives. So we didn't really know who we were dealing with on the other side of the table, and we started talking about the importance of IP and Licensing Executive Society. It's important to have a level playing field, both for licensors and licensees. And, you know, we're very concerned about this practice that's coming into vogue these days with efficient infringement. And he listened very politely for a little while, and then he said something like, well, that's all very good, but where's your data? And I sort of glibly replied something to the effect of, how much data do you need to have to know that unscrupulous people out there, freed of the constraints of criminal law, will appropriate the property of other people when they find that they can make a profit from it? So, of course, I say glibly because at the time I didn't fully appreciate the complexities that Andrei was facing at the time. And of course, he had a lot of people on the other side of the table lobbying in the other direction. But nonetheless, Andrei took what we had to say and, of course, went on to do great and wonderful things. in view of the policies and the objectives that I'm sure that he already had in mind. But I'm very pleased to say that LES was a big supporter, and we hope that we gave you some encouragement. So Andrei's many accomplishments, I recognize I'm not the keynote speaker here, so I don't want to spend all my time talking about his many accomplishments, but you know, there are a few things that are worthy of mention that I think have been really impressive, and he really did a great job of sort of turning around our IP system and making it a much stronger and more reliable system for IP owners and for innovators in general. So, of course, he advocated in general for strong and reliable IP rights. He came out early on with the Section 101 guidance, where he brought a great deal of predictability and reliability to the 101 issue that we're all here discussing today. He had various initiatives that he put in place to put prudent checks on multiple attacks on patent owners, including the institution of the FinTIV factors and discretionary denials of PTAB proceedings. He changed the standard and adopted the Phillips standard in claim construction in PTAB proceedings, as opposed to the de novo review, if you will, of the BRI standard that had pre-existed. He created also the National Council for Expanding American Innovation. So aside from just a focus on how do we support innovators, he tried to enlarge the tent, if you will, and create a more open and inclusive patent system that was more welcoming to those folks who are underrepresented within the patent system. So after all of this great work, Andrei then went on to join the Center for Strategic and International Studies, where he co-founded the Renewing American Innovation Project. He remains a devoted advocate for strong and reliable intellectual property rights in the public interest. His many speeches have received awards and recognition, including award-winning speeches that earned him the 2020 Cicero Speechwriting Award in both public policy and technology, and he has earned the IPO Champion Award from the IPO Education Foundation. And then, after doing all of that, Cincinnatus returned to the field and picked up his plow and went back to Irell and Manila, where he once again serves as managing partner. So please join me in welcoming Andrei Iancu.
Well, thank you, Brian. As I always say, it's a concern when the introduction is longer than the speech. But really, I very much appreciate all the very kind comments and the support from LES throughout the years. So great to be with all of you in person, finally, once again. This is fantastic. To the Eagle Forum, really one of the highlights every year, and we missed it last year, but so good to be back in person. So Ed, Jim, thank you for the invitation to be back. So many great people here. Dave Kapos, my predecessor, great to always get your insights and collaborate with you on so many different issues. And of course, Congressman Massey, one of the strongest supporters of intellectual property rights. I think he's has the most patents of any member of Congress. And I'm really, really excited that he's on the Judiciary Committee now. So now he can make a difference on our issues. So Kim was telling me that she's going to be funny. I said about the patent system, at a conference that's titled the Sorry State of Patentability. I said, I don't think I'm going to be funny. Well, so let me start with the news from a few weeks ago. General Motors closes all North American plants for a few weeks. Why? Because they don't have enough computer chips that are needed to make all of their vehicles. That seems troubling. When was the last time General Motors closed all of its plants? Let me tell you another story. On the 4th of July weekend, here in Washington, our dishwasher broke. So without calling a plumber, because why call a plumber, my wife says, we need to get a new dishwasher. Okay. By the way, this is better than 10 years ago when we ended up with a new house when the dishwasher broke. So we go to the local store in Virginia, and we spend like an hour looking at this dishwasher, that one, all the features, and we say, great, we like this one. Can we buy it? They say, sure, it will be delivered in November. That was in July. Like, what? It's a dishwasher. Why November? No computer chips. There is no supply of dishwashers. There's no supply of refrigerators. We are the country that invented semiconductors. We have the Silicon Valley. And we do not have in this country virtually any semiconductor manufacturing plants. Are folks paying attention to this? Are people listening? Are the leaders reading what's going on? On every measure that you can count, we are falling behind. On patents, in the technologies of the next industrial revolution, China now takes out 3 times at least more patents than the United States. Publications in scientific and engineering journals, peer-reviewed journals, more from China than the United States. On standards, standard committees, leadership roles in standards committees, they are taking the lead. Is anyone paying attention? In the technologies that matter, we are falling behind. Artificial intelligence, China gets 6 times more patents in deep learning than the United States. In 5G and 6G communications, think about the overall communications market out there. 40% of all new installations around the world, 40, last year came from 2 companies, Huawei and ZTE. The United States, the top 2, 9%, and it drops precipitously down from there. Quantum computing. China was the first to demonstrate quantum communications in the satellite network. Is anyone paying attention? You know, in 1957, the Soviet Union launched the first satellite in space, the Sputnik. Now, that was a shock to the United States because, at least at that time, we thought we were leading in the space race. We had cartoons, we had TV shows, we're going to go to space. People forget, but it was a shock to the system when they all of a sudden have a satellite in space and we don't. And then just a few years later, in 1961, the Soviets launched the first human being in space, Yuri Gagarin, circling the Earth. Well, that woke up our nation. At that point, people listened. Our leaders emerged. President Kennedy in May 1961 proposed that the U.S. should commit itself to achieving the goal before this decade ends, the 1960s, to land a man on the moon and returning him safely to Earth. Why? Well, you know his famous speech. He said in the speech in 1962 at Rice University, I'm going to quote at some length, because I think it's meaningful to contrast with the speech we hear from our legislators nowadays. President Kennedy said, "We set sail on this new sea because there is new knowledge to be gained and new rights to be won, and they must be won and used for the progress of all people." Keep in mind that at that time, going to the moon was a big deal. Not everybody agreed. In fact, 58% of Americans did not think we should do it. Yet he did it. And then he went on. But why, some say, the moon? Why choose this as our goal? And they may well ask, why climb the highest mountain? Why, 35 years ago, fly the Atlantic? And why does Rice play Texas? We choose to go to the moon in this decade and do the other things, not because they are easy, but because they are hard. Because the goal will serve to organize and measure the best of our energies and skills. Because the challenge is one that we are willing to accept, one we are unwilling to postpone, and one we intend to win, and the others too. Where are our leaders today? Sadly, instead of giving speeches about the future, some of our legislators and politicians are dwelling on a decade-old debate. Instead of committing our nation to win the next technological revolution, they give speeches lamenting failed policies of the past. Folks, this is our generation's Sputnik moment. We are living in it now. It is harder to see. You can't just look up in the sky and see a satellite. Where is this 5G thing? Where is this AI thing? How can you touch it? It's harder to define. But it is clear nonetheless that we are falling behind. And we are overly dependent on other nations to supply us with the advanced products that are needed today, not tomorrow. Is anyone listening? Where are the leaders to guide us through this Sputnik moment? The United States needs a commitment now to decide for the nation to lead in the technologies of the future. We need to commit ourselves to innovation and to inventors. To begin, at a minimum, the United States needs an innovation plan. This is just the beginning. Government, industry, academia needs to work together to develop concrete proposals that are forward-looking and guide the nation. The National Security Council on Artificial Intelligence that issued a report some months ago this year is a very good example. But it's only on AI, and it's just a report. Somebody needs to implement, or at least assess, those recommendations. But so much more needs to be done. We need to address research and development investment in the private and public sector, standard setting, and the importance of innovation in standards-based technologies and intellectual property protection for those technologies. We need to address advanced manufacturing, and we need to broaden the innovation ecosystem demographically and geographically so we can have more Americans involved in the innovation ecosystem. And of course, the nation needs to commit itself to the patent system, without which none of it is possible in the first place. This nation knew this from the very beginning. We seem to have forgotten. But from the very beginning, it's not a coincidence that the intellectual property clause is in the Constitution, and it's the only place where the word right is mentioned in the Constitution itself. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and technologies. Somebody, by the way, should ask how an exclusive right, which is constitutionally mandated, can be enforced by non-exclusive rights. The founders did not think this was controversial. In the Federalist 43, James Madison said the utility of this power will be scarcely questioned. I think there are a few people more than scarcely questioning it now. And instead of pitting one against the other, one industry against the other, inventors versus implementers, Madison said, the public good fully coincides with the claims of individuals. They understood 200 and some years ago that the patent system is a win-win. Everyone benefits from a robust patent system. You don't need to pit one group versus the other like they are relentlessly doing now every single day. Thomas Jefferson, the patent system has given a spring to invention beyond my comprehension. Abraham Lincoln, you all know all these. The patent system added the fuel of interest to the fire of genius. Ronald Reagan, who in 1982 said that throughout our nation's history, the patent system has played a critically important role in stimulating technological advances. Where are our leaders today? And of course, Phyllis Schlafly, in the book that has been mentioned several times today, recognized, she said, quote, "Only in America could such bold ideas actually be built, where men are free to invent and to invest in the certainty that they will own the product on which they pour out their talent, skill, and financial resources." Certainty is only brought by the patent system. Today's American leaders should follow these folks' example. Focus on the brilliance of our inventors and the critical benefits of a robust, balanced, and meaningfully enforceable patent system, instead of the relentless rhetoric about trolls and bad patents and poor quality and thickets and evergreening and countless other pejoratives that appear day after day in the writings, speeches, and bills of our own legislators. Instead of that, how about our leaders articulating on a consistent basis the brilliance of our inventors and incredible benefits of a robust patent system that our founders gave us? Instead of following the urgings of some countries for us to hand over our hard-won technology through waivers of intellectual property rights, instead of that, how about taking the lead on the international stage and explain to the world, by the way, as we have done countless times in the past in administration after administration, irrespective of political party, take the lead and explain to the world why IP is critical to innovation and the development of life-saving technologies, such as the very miraculous vaccines that we are working now to give up our IP on. And instead of threatening backwards-looking legislation that will restore guaranteed unlimited attacks on a patent, rendering it so much more difficult to enforce, and therefore reducing the value of innovation, instead of that, how about working together towards a balanced system that does not permit multiple bites at the apple and proposes forward-looking legislation that makes our patents meaningfully enforceable? Because you know what? While we are busy returning to the debates of a decade ago and to the failed policies of the past, China is not waiting. They are busy strengthening, in fact, their patent system. Just a few days ago, China announced plans to increase its enforcement mechanisms. Have our leaders read their recent, quote, guidelines for building a powerful country? Among many other provisions, it includes increased damages and punitive compensation for infringement. Is anyone in our government paying attention? While they're introducing bills these very days on weakening our enforcement mechanism, making it more difficult to enforce intellectual property. The Chinese right now, these days, are putting out in writing, it's not a secret, policies to increase. Who is paying attention? Look, folks in this room know that, backed by our constitutional patent system, American inventors have changed the world for over 200 years. It is incumbent upon us in this room, as difficult as it is, to relentlessly, over and over again, go tell those stories. Because otherwise, we are being drowned out. In 1921, at the age of 14, a farm boy from Idaho thought he could convert images to electrons and then back again. 14. So, at 14, while plowing a field with a horse-drawn harrow, Philo Farnsworth thought, hey, I can scan images like I can scan the field end to end, row by row, like I read a book. He then devoted his entire life to the invention of television. In fact, this became an obsession and the only thing he did professionally for the vast majority of his life. He got married young. I'm not sure this is a good part of the story, but nevertheless, it's exemplary of inventors. So he gets married young, and on their wedding night, he leaves his wife, goes to the lab, comes back. She is obviously seething, and he says, I have to admit something. There's another woman in my life, and her name is television. That's the story of many inventors. But in any event, at age 21, in September of 1927, with a camera in one room and a screen in a different room in the same lab, he and his colleagues viewed the first very grainy images and the first television transmission. He said, I was dancing around. I knew from my shaking hands, I don't know why he had to look at his shaking hands, but he says, I knew from my shaking hands how emotionally impacted I was. And they asked him, how did you manage? Nobody had done this before. How did you do this? So he says, towards the end of his life, he said, we did not know it could not be done. So we just went ahead and did it. In 1927, after that demonstration, he filed for his patent. It issued in 1930 as patent number 1773980. He had hundreds of patents as well after that. In 1984, he was inducted in the National Inventors Hall of Fame. And then, by the time he was 63 years old, Kennedy's charge to the nation to go get the man on the moon materialized. Buzz Aldrin, Neil Armstrong, stepped foot on the moon in July 1969. Along with 1 billion people around the world, Philo Farnsworth watched Armstrong's famous giant leap for mankind step and speech. He watched it on TV, the TV that he invented decades earlier. He was now, even though 63, he had a very tough life. He was not well, and he died 2 years later. But he's sitting there watching with his wife, the only wife he had his whole life. and with tears in his eyes, he said, "This has made it all worthwhile." Inventors and true leaders working together have always changed the world. This is just one of so many stories. If the legal environment is right, our inventors will invent, and our economy will grow. But you need the leaders to work together towards that common purpose. Where are our leaders today? So to them I say, there's tremendous potential in the creative genius of this country. Don't squander it. Thanks all.
Thank you, Andrei, for reminding us how important you are as a leader. And my only deep regret is your wife did text and said, "Where's the dishwasher?" But that's right. She decided a new house is better. Thank you so much. Thank you for your friendship and your leadership. We have now, we're going to keep moving because, among others, a couple of you have to go back to work. Thomas has to go try to save the Republic. So I do want to, we've got another couple of awards to give tonight. And so I want to go through them. By the way, I think I'm supposed to, Thomas, you have to come up and stand here and look like you. I was going to say look pretty, but you have to come up here, Thomas. And Andrei, can you come back up, please? And the reason is because the Phyllis Schlafly Friend of American Invention Award, which was created a few years ago, these two men were our earliest recipients, and we're so grateful that they have been friends of ours and continue to lead on that. Let me see. David, I need you to come up. And also, where's Matt? Matt Dowd. Yeah, Matt, come on up here. By the way, plug Matt's monograph here in the law review. If you haven't seen that, they're by your seat. Sorry, Judge Michelle's. Well, you're on there too, though. I mean, you know, I know how law clerks are. You did all the work. I was a law clerk once too. So I think we've gone through. Director Yonko did so many things in the office, in his office, and same thing with David. And we just thank them so much. And also, Congressman Massey has been so helpful in standing up in so many ways as an inventor and as someone who can articulate what that means. And now on the Judiciary Committee, we're just so encouraged. And we created this award, Eagle Forum Educational Legal Defense Fund, to continue to identify and support these great leaders, as Andrei mentioned, and to help further and promote the patent exclusivity and make sure that we continue this fight. And we have, across the country, we have Eagle leaders and we have members of Congress, we have people that are growing to understand this conservative movement going forward. So we want to say again, thank you and recognize these four gentlemen. So let's give them a round of applause. Thank you. Okay, you're excused now. You can go back to your seat. So we have two more awards that we want to give tonight. And we are really excited. This is in particular important as we recognize these two leaders because of the bipartisan nature of this. You know, Phyllis used to teach us when you come together on these issues that matter, the Constitution, the key issues, you look for people who are allies, whatever party they're in. Now, more frequently for Phyllis, it seemed that the Republican Party was there. But in the case of patents, we have great allies on both sides. And so let me, as we identify our two recipients this year of the Phyllis Schlafly Friend of American Invention Award, we recognize Senator Chris Coons and Senator Thom Tillis and their unique role in helping to strengthen our patent system. As you all know in this room, but maybe those that are watching or some that are new, Senator Coons, just a few years ago, he crafted the Stronger Patents Act. And this sought to curb the less than fair, unpredictable Patent Trial and Appeals Board ability to invalidate issued patents. The Coons bill would impose on the PTAB, and many of you know this, the same fairness and due process constraints that federal courts must use. Importantly, it would restore access to injunctions against proven patent infringers. And Senator Coons sought outside input, including from us, Eagle Forum, other partners, and wanted to know how, in drafting the Stronger Patents Act, he could make it both more effective and also get more buy-in. As we heard earlier from Brad, the process on these important issues and in Congress must include the buy-in and must include this working together to succeed. Senator Coons and Senator Tillis created and got the IP subcommittee reestablished in the Senate. And as chairman and ranking members, Senators Tillis and Coons did a lot of the heavy work to promote secure, reliable patents. And this was exceptional, and I think everybody was impressed with how much progress they made. The two of them also were very supportive of Director Yonko in his administrative efforts on patent eligibility guidance, the PTO rule, adopting the Phillips claim construction standard. I like how this was Jim and I went back and forth on this text. The senators also nudged Mr. Iancu to rein in PTAB from granting numerous challenges against the same patents. The two of them, again, bipartisan, working together, wrote, quote, "Serial petitions appear to reflect coordinated efforts by certain organizations to undermine the strength of our patent system." They aren't afraid, these two senators, to lead on this way. The two senators backed the PTO and Justice Department's withdrawal of the 2013 Joint Policy Statement on standard essential patent remedies, and they urged and supported the 2019 replacement Joint Policy Statement, which so many people here also gave input on. Senators Tillis and Coons have engaged, and we saw this with Brad being here and Senator Coons' staff over the years. They've engaged IP stakeholders in developing a framework toward a broadly supported legislative remedy on 101. In 2019, we've heard about the marathon hearings with 45 witnesses. Many of you were part of that, and we appreciated those hearings. And that testimony detailed the patent-eligible subject matter mess, kind of sort of what we were doing today, talking about the problems, and also gave a way forward. Earlier this year, Senators Tillis and Coons, and now they've been joined by Senator Cotton, Senator Hirona, urged the PTO to seek more input regarding patent eligibility. We heard earlier about the challenges that's going on with the current leadership at the office, and these two senators are on the case. They wrote, quote, "We can no longer continue to ignore the fact that current eligibility jurisprudence has had a dramatic negative impact on investment, research, and innovation." And they continue to push. In short, we're pleased and honored, encouraged to honor Senator Thom Tillis and Senator Chris Coons for their work, bipartisan work to strengthen our patent system, and as we go forward to build on their initiatives and to build on their ability to grow in the Senate, more leadership, and in the House with Thomas Massey to grow more folks who will support this. And so it's my pleasure to award the Phyllis Schlafly Friend of American Invention Award to Senator Thom Tillis, whose chief counsel is with us, Brad Watts, to accept it, and to Senator Coons in absentia. He had a conflict tonight, and we'll deliver that award to him. So please, Brad, if you'd come up, and we'll give this award. So thank you, Brad. Oh, good. See this? Thank you. Want to say a few words or anything? Either of you?
Thank you to all of you for the award, and we're very glad to accept it on behalf of Senator Tillis. It's truly an honor, and not just an honor because of the group it comes from and the esteemed individuals who've gotten it before him, Andrei, Judge Michelle, and so many others, but it's an honor personally to accept it on his behalf because he is, truly a good man and a gentle man in every sense of the word. one of the beautiful things about working for him as a staffer is he is someone who is committed. He is someone who believes deeply in the things he does, and he is someone who is willing to do the right thing, even if it is hard and unpopular. And, you guys talk about the hearings we did in 2019, and, how many other senators, when they were in cycle and would take God knows how many attack ads from anti-patent foes or from groups like the ACLU, would do it regardless because they believed it is right. And I think this award is so meaningful because it's a testament to the fact that he is always willing to do that, even if it's hard, and it's good to know that that's recognized and appreciated. And so he loves working with all of you. So many people in this room are his friends and his mentors, his guides and his advisors, and we are just so very thankful, Susan and I, to be here on his behalf and to accept this. And so thank you for the honor.
Thank you. Well said. Thank you. Thank you both for being here. We have, again, as a few final observations. Kim is going to come up. The pressure's on. Kim Chotkowski, she's supposed to be funny, according to Andrei, so we'll see how this. Vice President and Head of Licensing, Strategy, and Operations at InterDigital, one of our great sponsors and supporters. So thank you, Kim. Please, be funny.
Well, I could dance. Unpredictable and unstable. Irreconcilable, incoherent, and against our national interest. Disparate and inconsistent in application. At a loss as to how to uniformly apply. Significant confusion. Dorky, wonky, murky. These are the phrases I heard used today when describing 101. Some of you in the room might even recognize your own phrases. It's a hot mess. That's my phrase. We all know 101 by now. Whoever invents or discovers any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof may obtain a patent, therefore, subject to the conditions and requirements of the title. Those requirements: novelty, unobviousness, and written description. Like one of our speakers today, dare I say 28 years ago as a law student, I thought my biggest requirements that I needed to understand were 102, 103, and 112, the challenges for understanding patentability. I even remember meticulously drafting out a decision tree as I studied 102 to sit for the patent exam. At the time, I thought 102 was the bane of my existence. Then along came Alice. Alice left us with 2 steps. Easy, 2. Anybody can walk 2 steps. Anybody can do 2 steps. How hard can this be? So let's walk through these 2 steps. Assuming that claims are to a process, machine, manufacturer, composition, of matter, we first determine whether the claims as a whole are directed to one of the 3 exceptions: abstract ideas, laws of nature, and natural phenomena. And after determining that, we decide whether the claim contains significantly more than a patent upon the ineligible concept itself to transform to the invention into a patentable subject matter. At this point, I took a pause and decided to look up abstract ideas. And actually, I decided to Google, and I use Google in a very generic trademark sense. No. I looked up abstract ideas, I looked up laws of nature, and I looked up natural phenomenon, and here's what I found. An abstract idea is one that lacks concrete physical details, things you cannot touch that you know exist. And these were the 3 examples that my search engine provided. Love. It's abstract. But I've been married 25 years, and there's a piece of paper that is telling me that is not abstract. Government. We're here today. You can't touch it, but we all know it exists. It's not very abstract. And freedom. Well, that's just another word. So laws of nature. What we now learned, and this is in my world because as an electrical engineer, But however, I did do a search, and it defined laws of nature to be to be defined as stated regularity in the relations or order of phenomena in the world that holds under a stipulated set of conditions, either universally or in a stated proportion of instances. I got 7 laws in one search, 3 in another, that talked about laws of nature. As an EE, I spent a lot of time with Ampere-Maxwell's law. Fun times, I got that. I know what some of these laws are. But what I did leave in understanding the laws of nature after 4 years of college is F equals MA, V equals IR, and you can't push with a rope. So I've got those laws of nature. And then finally, I looked up natural phenomena, and I got a list of about 34. I have 3 favorites. The breaking of dawn, it's quite beautiful, a rainbow, and fermentation. So apparently this is the one time the search engine failed me. So in clarifying my understanding of a topic, I naturally turned to the best forum I could think of, the courts. And how do you think that turned out? Well, I guess we're still waiting. We are told by the courts one way to determine if a claim is directed to one of the exceptions is to consider whether the claim transforms the exception into a practical application of the exception. The Supreme Court made clear to transform an unpatentable law of nature into a patentable eligible application of such law, one must do more than simply state that the law of nature while adding in words apply, blah, 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 blah. Keep going. It's just that confusing. And if we in the patent bar and the IP community are confused, you can only imagine what the general public is thinking. So on that note, in all seriousness, let's talk about the impact of 101. The confusion and unpredictability in applying Alice is having widespread commercial ramifications at all levels for inventors. Those who fund innovators, those who turn innovations into products and services, creating jobs and opportunity for Americans, and patients and consumers who benefit from the products and services, to all the great detriment of the commerce its motivating force, innovation and competition is being stifled. It's not funny. The real-world adverse consequences of Section 101, uncertainty, impact, and the incentive to innovate, and add to investing in new technology frontiers, including life-saving treatments and diagnostics. Patent applications are routinely denied under 101. We talked today, China, Europe, they're surpassing us by being able to grant these types of applications. They're only threatening America's ability to maintain its leadership role in innovation, defense, and economic superiority in the global stage. This seriously undermines the longstanding world-class innovation environment and threatens the national global competitiveness. From a company perspective, the threat is very real. InterDigital is a Delaware company that designs and develops technologies that enable mobile communications. And since our founding in 1972, we have pioneered a wide range of innovations that are used in digital, cellular, and wireless products and networks, including the Gs, as I said earlier today. Our incredibly talented engineers have a long history of innovation and leadership. And in my early days at InterDigital, for 5 years, I touched each one of those engineers. 99 I wrote patents for. Thousands of patents we're still litigating and working on today. It was truly an honor and truly an incredible experience. More recently, we've been developing in the 5G, the world's first demos of 5G, and we're already looking ahead to 6G. In view of the current lacking clarity of sound patent eligibility, however, the incentives to innovate and invest in promising technologies are challenged. The resulting effect is that the current state of the U.S. patent system does not accurately reflect the purpose of Article 1, Section 8, Clause 8 of the U.S. Constitution with respect to discoveries. I call on this group today and say that while the glass may be half empty or half full, in the world of Disney, it's a great, big, beautiful tomorrow. We can do this as a team, and we can do this as a IP community. And so we thank the Eagle Forum for continuing this fight and continuing this message and keeping this alive. And we hope to work together with everybody in the community for stronger IP, for a better company, country, and the global world. It's been an honor to speak here today. I hope that my brief remarks have not kept you from your train, your home, or your bed. And just by the way, in case you were wondering, I did pass that patent bar, number 45012, signed by Q Todd himself, who I honor. So thank you guys very much for tonight, and I look forward to an opportunity to see you guys in the future.
Thank you, Kim, and thanks for your support. Let me say again thank you to Andrei Iancu for being such a great support of ours and being here tonight, and to our sponsors again, Akasha Research Group, they're over here, Bio, Dinsmore and Shohl, Innovation Alliance, and InterDigital. All of them stepped up to help us as usual, and we're so grateful. Thank you again to Jim Edwards for all his work. Ryan Height from our team, he's a communications director, and he's also our technical guy, so thank you, Ryan, for all your good work, and Joanna Spilgers back here, who is our administrator out of the St. Louis office, and so thank you for all that. On behalf of John Schlafly, myself, and Eagle Forum, Educational Legal Defense Fund, thank you for being here, for your support. We look forward to working in the future with you. Anything we can do here, our main office is in St. Louis, but we keep an office up on Capitol Hill on C Street, what John likes to refer to as a safe house. It's unmarked on the front of the building, if you've been there, and it's 2 doors down from Mitch McConnell. So we have security on the block all the time, so it's very, very safe. So if you ever need a place to meet, John's safe house is available. So thank you all. Have a great night. God bless you, and thanks for being together.